When leasing your commercial property, it is essential that you have some sort of binding commercial real estate contract. Failure to do so can lead to legal and financial complications. Commercial real estate contracts, also known as commercial property leases, commercial lease agreements, generally binding agreements that outline the terms and conditions of using a commercial property. The key elements of a commercial property include the parties, identifies the landlord and the tenant, along with their contact information, the legal address, the legal name for these people. The property, the agreement specifies the address and description of the property being leased, exactly the legal definition of what the property is. Now, as a landlord, you should ensure that what the purpose you're leasing the property is exactly what's permitted. Failure to do so can lead to many problems. With this permitted use, you have to include the restrictions and exclusions. So ensure that is done correctly. The lease terms. Now, commercial leases generally much longer than residential leases. Normal commercial leases between 4 and 10 years, sometimes longer. So in the lease term, you include the initial term, plus options, rent increases, and options for renewal. Next term is rent. The agreement outlines the rental amount, payment frequency, and provisions for rent reviews and increases. Security deposit. Now, all leases require a security deposit, generally around 2 to 3 months, could be up to 6 months, sometimes longer for major leases, and depending who the tenant is, and who the landlord is as well too. Outgoings. Now you've got net leases, and gross leases. With gross leases, the rental amount includes outgoings. With net leases, you add the outgoings, depending what you negotiate. So the outgoings could be things like property management, taxes, insurance, and maintenance issues, and utilities, etc. With many leases, the landlord may decide to help with the fit out. Maybe in agreement negotiations, there may be a cash injection of, say, monetary cash injection for fit out for the property, or there could be some sort of rental incentive discount or free period or something like that for a fit out period, so that there's some incentive to attract the tenant and to ensure the property is up to a high standard, so everyone's happy. Termination. The contract outlines the conditions of terminating the lease and the consequences of a breach of contract. The main term is subletting and assignment of lease. Now, when you've got rent a large premises, many times the tenant, because of things may go quiet, may decide to sublet it, and they may ask permission. So normally leases do have a clause in it for subletting, where there's a business involved. And the tenant may approach you and say they've got a buyer for the business, and obviously they sell the business, and with the business comes a property, which has got a lease in place, which you're a landlord for. This is what's called an assignment of lease. Now, if the new buyer of the business, the prospective new tenant, has got the capacity to run the business and to pay the rent, so they've got experience for that business, and they've got good assets or previous history of payments, it's very hard to reject them. In fact, those laws are pretty strict. You've got a very good cause. So if they're basically qualified in that respect, you cannot reject the assignment lease. Now, ways of drawing up a commercial lease. Depends where you are. There's 3 main types. First one is the long lease. I would call it long lease, drawn up by your lawyer, attorney, which I would strongly recommend. There's also a real estate lease. The real estate agent in some states, territories and countries may allow for the real estate agent to draw up a lease. Usually has a limit of, say, 3 years. And a third one, which is never talked about, is what's called an estoppel. For example, a handshake. That's the cheapest of all. It's free. But there are a series of repercussions when you make verbal agreements, or written agreements for that matter, with a prospective tenant without consulting your property consultant and lawyer. The costs real estate lease drawn by the real estate agent is probably a fraction of the cost of a lease drawn by a lawyer. And estoppel is pretty much free, but are binding. It can be binding. I've got a video, I'll describe that in great detail about personal experiences with estoppels, which give you an idea of what the repercussions could be. So be very careful when you make handshake agreements with new tenants. So discuss this with your commercial property consultant and your specialist commercial property lawyer. The two main types of commercial leases are retail leases, which usually have stricter regulations. Then you've got general commercial leases, which cover everything else, industrial, office, various. So, there are some other special leases for example, hotel leases, medical type leasing, complex agreements. So generally, they are the two main ones, retail leases and general commercial leases. I can't stress enough how you should work with an experienced real estate coach or consultant, working with a experienced professional commercial real estate lawyer to protect your interests. Given the complexities and legal implications of commercial real estate contracts, it is highly recommended that landlords and tenants seek legal counsel before signing an agreement. So when you work with your commercial real estate consultant and commercial real estate lawyer, they can help you negotiate favorable terms, ensure the contract protects the interests of both parties and addresses specific needs. Understand legal obligations, clarify the rights and responsibilities of each party to avoid further disputes. Draft it in clear and concise language, avoiding ambiguity and potential misunderstandings. Misinterpretations can lead to conflicts. And finally, ensure that the lease is registered, properly registered with relevant authorities, providing legal protection for both parties. For commercial real estate investors, understanding the intricacies of commercial real estate contracts is critical. A well-drafted and properly negotiated contract can secure a reliable income stream. Lease agreement ensures consistent rental payments from a suitable tenant, helps you minimize financial risks, clearly defining the terms and conditions, protect against potential losses due to tenant default or property damage. Maximum property value. Well-maintained property with favorable lease agreement attracts high-quality tenants and increases market value. So if you've got a tenant consistently pays you the rent on time, looks after the property, buyers see this, and it attracts them. It's simple as that. By understanding the key elements of commercial real estate contracts and seeking professional legal advice, investors can make informed decisions and protect their investments in the dynamic commercial property market. I'd like to hear your comments. If I can help you, contact details with this video.